Okay, so the first thing we're going to do is try and understand the legislative framework. As you know, in Australia, we've got three levels of government. We've got the federal level, state level, and the local level. Ultimately, Australia's key environmental laws and regulations related to land use and conservation are developed and implemented under what we call the Environmental Protection and Biodiversity Act. That was formed in 1999 and it's been reviewed every 10 years. It gets reviewed. It really came into effect, and why we needed this was this general framework is that under the Constitution, each state can develop their own environmental laws. And under the Constitution, the environment actually isn't recognised in the Constitution at that federal level, at the Commonwealth level. But what is recognised is our commitment, essentially, under international law. So if we commit to, a whole range of targets or biodiversity acts overseas, those sort of things, World Heritage Areas, Ramsar, ultimately the federal government can actually overrule any state government legislation. And we saw that with the Franklin Dam down in Tasmania. The Wilderness Society stopped the Franklin Dam going ahead, which was a state government proposal, because it was going to impact the World Heritage Area. So it won. They won the case, and from that, it basically led the states and the government to develop the EPBC Act to actually create the framework so that the state government legislation fits smoothly and is essentially guided by the federal government Act, the EPBC Act. Okay, so in 1999, the Act was enacted by the Australian government to essentially create a national framework for environmental protection and biodiversity conservation. It was developed through a consultative process involving public consultation, scientific input, stakeholder agreement, but ultimately the states and federal governments needed to come together to create that framework. So state government legislation, which to a large extent, this is what we're, in each state, you're governed by the state government laws, recognise the values of these frameworks. So essentially, local governments don't necessarily have their own environmental policies per se, like for the environment. They work under the state government legislation, which is then essentially developed within the framework or the federal framework of the EPBC Act. It was, to a large extent, was driving, as I said, the World Heritage Area debate and our obligations that had to be met internationally. So the EPBC Act really does focus on protecting and managing what we call matters of national environmental significance. So these can include things like threatened and endangered species, ecological communities, migratory species, those that are moving between international waters, Commonwealth marine areas, Ramsar, wetlands, World Heritage sites, and nuclear actions as well. The Act provides the legal framework for the assessment and approval of activities that may have impact on these matters of national environmental significance. But ultimately, like I said, there's a whole, depending on what state you are, there's a whole range of state legislations that govern land use and environmental protection. State laws in Australia are actually shaped around this EPBC Act from 1999, and through a combination of coordination, cooperation, and legislative processes, the state frameworks or the state governance of the environmental land use is actually governed by that Act. So while it's a federal legislation, it sets the framework within states and territories to develop their own complementary environmental laws. And that's how it kind of works in Australia. So you're governed by state laws, that really have been informed by the federal framework. So overall, state laws in Australia are shaped around this EPBC Act through things like what we call cooperative federalism, MOUs, complementary legislation. You can have accredited processes as well, joint management. Really, there's a whole range of things to just harmonise this legislation. But ultimately, so if a state does develop a law that's outside of this act, the federal governments can trump it, and basically they have ultimate control of that because of these international obligations to a large extent. So that's essentially the framework of legislation. So ultimately, the EPBC Act from 1999 really does inform our frameworks going ahead. We do have, some different names for different legislation in Australia under the different states. So, for example, in New South Wales, we've got the Environmental Planning and Assessment Act. In Victoria, they've got the Planning and Environment Act. All common themes related to, developed under different frameworks. Environmental Protection Act in WA, Nature Conservation Act, and they're constantly being updated and changed as well. But basically, for anything like land clearing or even positive initiatives, they will fall under and be accredited or permitted through state-based legislation that has been set within the framework of the EPBC. So what we're going to talk about next is a whole series of a series of audio or podcasts that we're going to actually start talking about some of these positive initiatives that you can listen to. So listen to them in their own time. Thought we'd just try and clear up the legislation stuff, and I hope we've done that. But that's essentially the starting point here to actually understand the legislation. So thanks.